Thank you so much, Mr. Speaker, and thank you, distinguished senators. As indicated, my name is Elisha Ngoya, lead counsel for the governor. Before I address you on another substantive preliminary question on an existing court order touching on these matters, allow me to invite my learned colleague, Mr. Elias Mutuma, to wind up on that issue of the proceedings before the Assembly by drawing your attention to certain salient material aspects of the purported Hansards that have been presented before you, so that you have all that in consideration. Then I'll move to the next subject. Thank you so much, Mr. Speaker.
Completely deserted ghost city.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity.
Breaking news, YouTube has released new updates about monetization and tax, and I've seen a lot of creators.
That what we have raised is not a preliminary objection, but requires an interrogation by way of listening to witnesses and making a determination based on what they will say. But our submission is simple, honorable senators, that what we have raised is a pure PO that can be addressed and determined based on what has been presented by the County Assembly of Isiolo. Honorable senators, my understanding of Hansard's records is that they are a verbatim record of what transpires in a House proceedings. Therefore, they are able to tell us exactly what happened on the day that that motion is said to have been passed. We have raised an issue with proceedings that are said to have taken place on the 18th of June 2025, and proceedings that are said to have taken place on 26th of June 2025. Honorable senators, with your kind permission, kindly hold your volume 3 of the County Assembly's documents. I will take a very short time to take you through the Hansards, and this being a house that is also a house that is very much familiar with proceedings in the House, you'll be able to tell me whether there is anything that took place there. At page 7 of that bundle, we have been presented with what is said to be the proceedings of 18th of June 2025. Page 7, or 7, Saba, 7 of volume 3 of the documents. Page 7. We see the House purportedly sitting for the first time. There is no communication from the chair. There is no calling of orders by the clerk. Straight away, the mover of the motion proceeds to execute the business of the day. Look at it. It is straight away withdrawal of the motion on the impeachment of Isiolo County Government dated 10th June 2025. What does it begin with? Honorable Abubakar Godana. Honorable senators, who presided over this session? There is no invitation from the Speaker for the mover of the motion to proceed and execute the business of the day. Let's proceed. Honorable Abubakar Godana proceeds and proposes a motion to withdraw the previous motion and invites two members of the County Assembly, Honorable Nicholas Lorot and David Nyoro, to second the motion. Without again the intervention of the Speaker, these two members rise and they proceed to second the motion. So who invites them to the floor? Who is presiding over this House? Let's go on. The two members support the withdrawal of the motion, and the Speaker now is seen for the very first time. There is no question put to the members. There is no vote that has taken place, but the Speaker proceeds to say, the members, the notice of the special motion of the removal from office by impeachment, the Governor of Isiolo County issued on Tuesday, 10th June 2025, has been officially removed as requested by the mover, Honorable Bakar, member for Sericho Ward. We now proceed to the next business. So who approved this withdrawal? Who approved this withdrawal? Where is the vote? Let's proceed. Honorable Senators, we proceed to the Hansard now of 26 when the governor is being purportedly impeached. That's at page 23 of the same document. There is a communication from the chair. The first order of business, you will come across the order paper at page 17, where we have a total of 8 orders of the day. 8. But when you go to page 23, we do not see the clerk calling out the orders. Just look at it. It is the speaker directly proceeding to make a communication. Is that an anomaly, Honorable Senators? We are all familiar with the business of the day. But what intrigues me more, Honorable Senators, the first order of the day here is to lay on the table the purported public participation report, which is done by Honorable David Lemantile, allegedly. He prosecutes his motion and argues on the public participation. Let's go to the end at page 31. But before that one, let's go slightly at page 30, where he completes his submissions. After laying the paper, public participation, we now see Honorable Peter Lawson standing up to second this motion. Who has invited him to second this motion? Out of nowhere, he's not invited by anyone, but Hansard show that he rose to second this motion. And then the speaker proposes the question and it opens the floor to the members of the House. At page 31, the last member seen to be speaking is Honorable Francis Letimalo. The speaker now puts the question. So what happens after the question was put, Honorable Senators? There is no record whatsoever of what transpired. Nothing. A question is put. There is no indication that the House actually endorsed the public participation report. That Hansard is left hanging. Honorable Senators, after that paper is laid, the Speaker does not even call for the next order. The clerk is not seen anywhere calling for the next order. Instead, what do we see? Honorable Abubakar Godana is seen now on the floor. Hansards are supposed to be capturing verbatim what transpired. So who was in charge of this House? Where is the Speaker's recording inviting the mover of the motion to move the motion? Where is the recording of the clerk inviting, or rather calling for the order, for the next order? There is nothing. Instead, we just see someone on the floor prosecuting the motion. And he proceeds and proceeds. At page 35, he's done. Strangely, the first paragraph at the top of page 35, when he completes to execute his motion, he does not invite anyone to even second. Records are there. But we see one Honorable Major Golicha now standing up to second the impeachment motion. Who has invited him? There is no one. And other members, strangely now, so the House is suddenly in an autopilot. So from Honorable Major, then we see the Speaker opening the floor. You have Honorable Peter Losu. He continues. Without the intervention of the Speaker, there is another member, Honorable Salesio Kiambi, who proceeds as if the Speaker is not in this House, as if the clerk is not in this House, and proceeds. Another member just rises up from nowhere. There is no recording of the Speaker inviting any member to make a contribution to this motion. Apart from, of course, page 39, when suddenly the person cooking this answer realizes the Speaker has not been captured in this, and now we see the Speaker for the first time. In conclusion, because I do not want to take time that my senior is going to take to address you on the other issue, look at page 41. After the members purportedly complete to make their submissions, the Speaker makes very strange remarks, and I quote at page 41. Clerk, is the Governor or his legal representative available? Sergeant at Arms, can you check around if the Governor or his legal representative are present? The Speaker does not even take time to communicate to the House whether the Governor had been invited. He does not even read that invitation notice as required. So why is he calling for the Governor, whom Learned Counsel had told you was invited to appear at 9 and we at 2 o'clock? The Speaker is not seen anywhere saying that we invited the Governor by this letter and he has not come, but instead asked the clerk to check whether the Governor is available anywhere. Let's proceed. I'm completing, Honorable Senators, and this is going to shock you. So, when the Governor was confirmed was not in the House, the Speaker proceeds to guide the House on the next move. At the end of that page, 41, I read what the Speaker says. When the doors, I'm reading the last part, when the doors have been locked and the bar drawn and the names of the tellers have been announced, the Speaker shall, this is the Speaker telling them, the Speaker shall put the question again in the presence of the tellers. When called out, each member shall thereupon rise in his or her place and declare assent or dissent to the question in the following manner. I vote yes or I vote nay. Proceeds. Honorable Senators, page 42. Where does the Speaker put that question to the members of the House present? There is no question put whatsoever. She has just told them that he needs to put that question again. There is no question put. So what were these members voting for or against? There is no question put. Honorable Senators, we then need to sit here and invite witnesses on the stand to demonstrate that there was no proceedings that took place on 26th and 18th. I rest my case.
Thank you, Mr. Speaker, and thank you, distinguished senators. I'll proceed to argue the final limb of the objection, but just to cap up what my learned colleagues have told you, that if before you is a purported Hansard in the form and content that you have been taken through, if before you is a purported Hansard that no one has taken the courage of his or her conviction to certify, if somebody brought before this House a Hansard that is not certified, because certification is done by a particular officer whose signature we can tell, is what is before you a Hansard of the County Assembly of Isiolo or a mere piece of paper? And if we conclude, as I invite you to, that what is before you is a mere piece of paper, to the extent that it is not certified, can we take any other proceedings on the strength of that mere piece of paper? That is what makes this issue a proper preliminary objection for resolution, one way or the other, before we can go into the trial. Secondly, is the issue of the order of court. And I want to address this issue as follows. We are guided by the Constitution and other laws and the standing orders, and to an extent, the manuals that this House publishes from time to time to inform both these members and the members of the public who interact with this House. My research has revealed that the latest manual issued by this House is a manual entitled Removal from Office of County Governors and Deputy County Governors Through Impeachment, an easy-to-use manual on the procedures and rules. That manual, on the face of it, was published by the Directorate of Legal Services and the Senate Liaison Office in the year 2025, which is this year. Part 3 of that manual is entitled Judicial Proceedings Against Impeachment. And this is the position this House has communicated in that manual at page 60, which is the very last page of that manual. There are 2 subtitles at page 60 of that manual, which is subtitle 1, Comply with Court Orders. And it says, parliamentary privilege and immunity and the principle of separation of powers do not shield the county assemblies and the Senate from court orders. When court orders are issued, they are binding on the county assembly and the Senate and must be complied with. Failure to comply with court orders may result in the invalidation of the entire process of impeachment by the courts. Then the second subtitle is Participate Act Solution. If court orders are issued against a county assembly or Senate, the most preferable option is to participate actively in the court proceedings. The county assembly or Senate may apply for review of the court orders or appeal to the next court for variation or the setting aside of the court orders. That is the manual that this House has published as late as this year. Allow me to make the following submissions then. The existence of the orders of court I am going to refer to is not a disputed fact. It is a fact admitted by the county assembly in their written submissions. So the existence of these orders is not a contested issue. And it not being a contested issue, it follows therefore that this Senate can proceed right away to resolve the question of the impact of those orders without investigating whether they exist or they don't exist, because between the parties, it is an admitted fact. Allow me to begin by referring this order, this Senate, my apologies, to an earlier ruling of the Speaker of the then only House of Parliament, which was the National Assembly, before the new Constitution. This was the ruling by Speaker Kenneth Otiato Marende on the question of nominations of Chief Justice, Attorney General, Director of Public Prosecutions, and Controller of Budget, and that ruling was made on the 17th of February 2011. It is found in volume number 4 of the governor's documents. It is found in volume number 4 of the governor's documents, and you'll find that ruling starting at page 165 of volume. But the relevant part I will refer to in the interest of time is at page 168 of that volume, volume number 4 of the governor's response. At page 168 is a continuation of that ruling of the then Speaker of the National Assembly, Honorable Kenneth Otiato Marende. He says, and I quote, "Honorable members, Between the time when Mr. Imanyara first raised the matter and now, I have had the benefit of considering a range of material addressing the various aspects of the matter. Specifically, I have benefited from, among others, the position taken by the Judicial Service Commission, the Commission on Implementation of the Constitution, and the Law Society of Kenya. I have also carefully read and considered the ruling of the High Court relating to the matter of nominations, which was delivered on 3rd February 2011. Mr. Speaker, distinguished senators, I had the rare privilege of participating in that court proceeding. The first three of these bodies are constitutional or statutory, and their views on matters of law, though not binding to this House, are of significant persuasive value. Honorable members, as for the ruling of the High Court, despite my restatement of the constitutional relationship between the legislature and the judiciary, I have repeatedly emphasized that subsisting judicial decisions, while they cannot restrain the legislature, and that's important to us because I'm addressing this issue, while they cannot restrain the legislature from the discharge of its functions, are of binding effect and may have a bearing on the products emanating from this House. The learned Honorable Justice Musinga, in his ruling in the above case, found that the nomination of the Chief Justice was unconstitutional, for it was not in accordance with Article 166 of the Constitution. I will then proceed to page 169 of that volume in the interest of time. The paragraph starting with honorable members, that will be the third paragraph. Although I have read that this court decision does not stop the National Assembly from proceeding with its work and cannot determine for the House how to proceed, it must be noted, as matters currently stand, any decision made by this House on the nomination, though perfectly procedural from the point of view of the legislature, outside the legislature, it is, to the extent that it does not accord with the ruling of the court, null and void for all purposes. So that is the guidance that Honorable Marende makes. Allow me to then come to the specific ruling that we wish to draw this Senate's attention to, and that I will refer you to volume number 4 still. Thank you so much, Mr. Speaker. And as somebody who has been here multiple times, I'm always impressed by the support we get from the administrative teams in this Senate. That may have to go on record in the interest of posterity. At page 13 of volume number 4 is a decision of the court in Isiolo High Court, constitutional petition number A004 of 2025. The parties are Honorable Abdi Ibrahim Hassan, the governor now before you as petitioner, and the County Assembly of Isiolo now before you as the first respondent. There are two other parties in that matter, but safe to highlight that the parties before you are parties in that suit. They are therefore bound by the decision of that court. At page number 25, allow me to just go straight, Mr. Speaker, to page number 27. You'll find a paragraph 28 of that ruling. And the judge observes as follows: it is important to note that there was no complaint raised when the first orders were issued by the court in respect of the motion dated 10th June 2025 that was to be debated on 17th June 2025. In fact, the sentiments by the mover of that motion, the contemnor, actually vindicate the court, as he has in his affidavit considered that the motion was defective in substance and marred with procedural irregularities, the very grounds that the petitioner has sought to rely on. The mover of this motion went to court and told the court, it is true that the orders you gave first were right, because the motion I had tabled was marred. It was defective in substance and marred with procedural irregularities. The move of the motion. Allow me to then take you to paragraphs 45, 46, and 47 of that ruling at page number 35 of volume number 4. Paragraph 45, the judge says, therefore, it is the finding of this court that the motion dated 18th June 2025 and debated by the first respondent on 26th June 2025 was in contravention of the conservatory orders of this court issued on 25th June 2025. Hence, the resolution arising therefrom is null and void. Once an act is declared null and void, it is of no legal consequence. A court of law has found that this motion, which has now been brought here before you, senators, is null and void. It is of no legal consequence. Paragraph 46. As stated, the resolution has evidently been submitted to the Speaker of the Senate. It is thus upon the Senate, once informed of the orders herein, which I'm now doing, Mr. Speaker, distinguished senators, to determine if it will proceed to handle the said resolution, thus abating a blatant disregard of the rule of law or the respect of orders. The matter at hand calls for a stand to be taken by the constitutional organs involved. What they choose to do will have set a precedent on the necessity for compliance with court orders. It is a choice between anarchy and constitutionalism. Distinguished senators, the judge is saying this. The judge is saying, I am aware. I cannot stop you from doing your work. So he's saying, proceed and go to Senate. And that, to my mind, was an extremely wise move by the judge, considering historical pleas for there to be institutional committee between institutions and to respect the powers of each organ. But the judge is saying, so you decide for yourselves how you will proceed. I have made a finding that that motion is null and void and of no effect. I want to contradistinguish this with other scenarios that the other side will draw your attention to shortly. The judge has not issued a conservatory order against this Senate. The judge has made a determination on the validity of the motion purportedly debated and purportedly approved by the County Assembly of Isiolo. The judge has made a determination. It is null and void and of no legal consequence. You are being invited to engage with this motion on that strength of fact, on the strength of the finding by the judge that the motion as approved, as brought before you, is null and void and of no legal effect. We therefore invite you to introspect and make this determination. When the impeachment law calls upon you to determine a motion that has been approved by the County Assembly, is it just any motion or a valid motion? If there is information before you that the motion is invalid for any reason, what is the precedent that has been set by this Senate? It is against that background that I wish to draw this Senate's attention to its resolution that is found from pages 136 of volume 4 of the governor's documents. And this was the determination of the proposed removal from office by impeachment of the governor of Kericho County, Honorable Dr. Eric Kipkoech Mutai. On that occasion, the validity of the resolution was questioned on the ground that the motion had not met the threshold. And rightly, this House found that it could not move a step further because validity of the motion is an important precondition to the carrying out of the trial process on the motion. Similarly, by parity of reasoning, today, validity of another motion has been impugned on two grounds. One, there was no sitting known to law of the County Assembly of Isiolo to approve the motion. And number two, in any event, a court of competent jurisdiction has made a finding that whatever came from the County Assembly of Isiolo is null and void and of no legal consequences. Will you, in the face of the precedents you have set by previous speakers' rulings and by resolution in the case of Kericho County Governor's case, proceed to trial on that understanding? We beseech you with humility to find that there is no motion known to law before you and thereby to down your tools. I humbly submit and respect and rest the governor's submissions on that question of the preliminary objections. I reserve our 10 minutes, Mr. Speaker, for a rebuttal from this side once the County Assembly has finished their response. Thank you so much, Mr. Speaker. Thank you, Senators.
Counsel for the County Assembly.
Mr. Speaker, I will respond to the arguments that have been made by my learned colleagues for the governor, and I am the only member of the team for the Assembly that will respond to those preliminary issues. Mr. Speaker, I am grateful for the opportunity to respond to those preliminary issues. I shall constrain myself to the time that Mr. Speaker has gladly extended our way. Mr. Speaker, I wish to start my response to those preliminary issues by stating that a preliminary issue, by definition, must be an issue that goes to the ability of this House to entertain the motion before it. It cannot be an issue that is merely important to the governor. It cannot be an issue that is merely important to the governor. Sorry, I cannot see my time. Thank you very much. It cannot be an issue that is merely important to the governor. And the governor then chooses to bring it forward and deal with it as a preliminary issue, and it does not go to the ability of this House to hear the motion before it. And, Mr. Speaker, it is settled that a preliminary issue assumes that the facts are settled. Mr. Speaker, the consideration of what the Governor's Council purports to be a preliminary issue involves the detailed consideration of evidence. I was constrained to stand up on my feet and object whilst my learned colleagues were on their feet because it was apparent that what my learned colleagues were doing for the governor was leading evidence. They were testifying. They were referring to contested statements in the bundles of both documents, and there are responses from the County Assembly in respect of those statements. And those statements must be tested by way of cross-examination. And only once the evidence is laid before this House, and it is tested, like the Assembly is entitled to do, then can this House make up their minds as to whether or not those issues hold any water. I am not saying that this House should not consider those issues. But what I am saying emphatically is that this House should not consider those issues as issues that are preliminary to the determination of the motion. There are issues in the motion, and I will demonstrate in a moment how those issues are indeed issues in the motion. I will choose, or I have chosen to respond to the issues that were argued by my learned colleagues for the governor, using a slightly different framework from what they did. We distilled 3 or 4 issues from the notice of preliminary objection that was served on the assembly, and I wish to crystallize the first issue I wish to respond to as follows, Mr. Speaker. That the governor challenges the validity of the impeachment motion in light of the declaration by the High Court of Kenya sitting in Meru that the impeachment proceedings are a nullity. It is correct, as was submitted by Mr. Ongoya, that it is not contested that indeed there are orders that were issued by the High Court of Kenya sitting in Meru in respect of these proceedings. But what is contested, and I doubt we will agree on this, is the effect of those orders on these proceedings. Mr. Ongoya and his colleagues say that the effect of those orders on these proceedings is to invalidate them, and this Senate should therefore down its tools. We disagree. I submit, and I wish to submit, Mr. Speaker, and emphasize that elections to offices, such as those occupied by the members of this House, are conducted by the people of Kenya in furtherance of primordial sovereignty. Mr. Speaker, the exercise of removal of an elected official, such as the removal of a governor, is therefore, in my submission, the flip side of that exercise of primordial sovereignty. And as authority to my submission, I wish to refer, Mr. Speaker and members of this House, to the provisions of Article 1 of the Constitution. Mr. Speaker, Article 1 of the Constitution provides as follows at Article 1.1. It states that all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. That is an affirmation of sovereignty by the people of Kenya, and it is clear where the sovereignty lies. Article 1.2 then goes on to say that the people may exercise the sovereign power either directly or through their democratically elected representatives. The important provision of Article 1, which I wish to emphasize, is the next provision. Mr. Speaker, sovereign power under this Constitution is delegated to the following state organs, which shall perform their functions in accordance with this Constitution: Parliament and the legislative assemblies Parliament and the legislative assemblies in county governments, the national executive and the executive structures in county governments, the judiciary and independent tribunals. Mr. Speaker, the function of the removal of the governor is delegated to the Senate of the Republic of Kenya by virtue of Article 1.3. The election of the members of Parliament, members of the National Assembly, members of the National Assembly, members of this Senate, and any elected office is done directly by the people of Kenya. Mr. Speaker, as I have said, impeachment is the flip side of election, and it is done again here by the people's representatives. And here I wish to emphasize this point. Mr. Speaker gave a correct and appropriate direction at the beginning of these proceedings, that voting on this motion is by delegation. Voting on this motion is not by all members of the Senate, but it is by delegation. And I submit that that is in recognition of the special role, the special function that this House is being called upon to perform when you sit to consider the motion for impeachment. It is not legislative, but it is delegated, and the House has correctly interpreted that role as being exercisable only by delegations and not by all members. Mr. Speaker, it is my submission that a correct interpretation of the doctrine of separation of powers is as follows. Mr. Speaker, and it has been held how it applies to the power of legislative assemblies, county assemblies, and this House to carry out their function of impeachment. Mr. Speaker, there was reference to a decision that was made by Kenneth Marende when he was Speaker. And it was a decision in respect to the appointment of the Honorable the Chief Justice of this Republic. And I wish to distinguish that decision from the matter that is before you for this important reason. Mr. Speaker, I have stated, and I will take your permission to emphasize, that impeachment are time-bound proceedings. The appointment of the Honorable the Chief Justice, yes, was a constitutional process, but it had no time limit. And the process of that appointment had the luxury of time. It could take as long as it needed to take, and it then made room in it for judicial interventions during the process of the appointment of the Honorable the Chief Justice. I have stated, and I will emphasize, that impeachment proceedings are time-bound proceedings. And if they are not concluded in time, we would then be faced with the ridiculous situation where somebody runs to court and say that Assembly X or the Senate of the Republic of Kenya did not complete their mandate in time. And I believe I was seated here a few months ago when the impeachment proceedings of the Deputy President of the Republic of Kenya were being conducted. And that was an important consideration, the strict timeline that guided many of the directions that, Mr. Speaker, you made during those proceedings. I urge you to call on that wisdom and to find, if you are persuaded to consider this as a preliminary issue, that because of the strict nature of the timelines, then the room for court or the role for court is ex post facto considerations of completed processes of impeachment. Mr. Speaker, there is a decision that has been referred to, and it is a decision that we advocates all know, and I'm glad, Mr. Speaker, you are an advocate, and I'm sure you are familiar with this decision. It is a decision that is referred to in the submissions by the governor, and that is the decision of Lord Denning in the famous case of McFoy versus United Africa Company, where they seek to persuade, and in citing that decision, counsel for the governor seek to persuade you that because the proceedings are a nullity, then you should not proceed any further with these impeachment proceedings. I wish to rely on that decision, Mr. Speaker, and I wish to rely on that decision in an attempt to persuade you that it is indeed the proceedings before the High Court of Kenya in Meru that were a nullity, coming as they did, contrary to the established law and contrary to the established interpretation of the modern doctrine of separation of powers, prior to the completion of the impeachment proceedings. Those or that decision or references to that decision are a nullity, and you should disregard that decision and proceed. Mr. Speaker, I had a few passages from the decision, and learned counsel for the governor seemed to be suggesting that the judge of the High Court in some way may have been directing this House as to what to do with its orders. I submit that this House is completely independent under the Constitution of the Republic of Kenya, and you should be guided properly as you then consider this preliminary issue. But in conclusion, I wish to state that this preliminary issue is not a preliminary issue. It is based on contested issues of fact, which we should then get the opportunity to look into. The second issue that I wish to respond to is an issue that when I first encountered it, I was a little concerned. And that is the submission that has been made by my learned colleagues for the governor, and they have taken some time on it, that there were no sittings of the County Assembly of Isiolo on the 18th and the 26th of June 2025. They have used that submission in support of several grounds of their PO, and I wish to respond to that ground, and I wish to ask the House to apply it to all instances where they have made reference to the fact that indeed there were no sittings on the 18th and the 26th of June 2025. I wish to submit that that argument with tremendous respect to the governor and his team, is self-defeating. And it is a self-defeating argument if you look at it from this perspective. Mr. Speaker, it is the proceedings of the County Assembly of Isiolo of the 18th and the 26th of June 2025 that the governor has taken to the High Court in Meru, and it has resulted in the decision of Mr. Justice Nyaga, sitting in the High Court in Meru, which is set out, the order arising from Mr. Justice's decision is on, Mr. Justice Nyaga's decision, is on page 6 and 7 of volume 3 of the governor's document. And the ruling itself is to be found between pages 13 and pages 37 of volume 4. And having based substantive legal proceedings on the proceedings of the County Assembly of the 18th and the 26th of June 2025, it then cannot fall from the governor's mouth to come here before you this morning and assert that there were no proceedings. They have based substantive legal proceedings on the fact that there were proceedings. They have gotten certain orders from the High Court in Meru, which orders they seek to bring before you and urge you to declare the proceedings a nullity. I submit that they cannot. And for the completeness of the record, I submit that an estoppel arises against them approbating and reprobating in the manner in which they do. And an estoppel, for the purposes of my submission, is a legal principle which precludes a person from asserting something contrary to their previous action or statement. The contrary provision is that there were no proceedings. The previous action is that they took those proceedings to the High Court, persuaded the judge of the High Court that there were proceedings and obtained orders. They cannot do both. And for that reason, I urge you, I submit that that ground of the PO must fail. There is the issue that my good and learned friend, Mr. Theory, commenced with, and I wish to crystallize that issue as the threshold issue. The short and sharp answer to the threshold issue is that threshold, the determination of whether or not a motion surpasses the threshold required in law requires the consideration of testimony of evidence from both sides. And the consideration of evidence must of necessity, Mr. Speaker, include the testing of that evidence. There are witnesses that the governor has brought, and there are witnesses that the governor has brought, and their testimony was referred to in support of this submission. We, as the advocates who are present for the County Assembly, wish to test that testimony. We do not believe that what has been stated in those statements is correct. Those facts, Mr. Speaker, are therefore contested. And if they are contested facts, they then cannot form the basis in law or otherwise for a preliminary issue. That must go on to full trial, and in the context of these proceedings, that means the hearing of the motion that has been brought. Mr. Speaker, one of the reasons that the governor gave for in support of the submission that the threshold has not been surpassed was the fact that the minutes in support of those, the Hansard, sorry, not the minutes, Mr. Speaker, in support of those two proceedings were not signed. Mr. Speaker, we note that one of the governor's witnesses is the clerk of the assembly, the County Assembly of Isiolo. Most unusual in the circumstances, because it is the clerk's responsibility to sign those Hansard proceedings. We look forward to the opportunity, Mr. Speaker, to test the testimony of the clerk and get the clerk's explanation. And we believe this House can only benefit from that explanation from the clerk, who is charged with the primary responsibility of certifying those minutes, as to his explanation as to why those minutes were not certified. The clerk is a witness. He has put in a witness statement or an affidavit, and we wish to test his testimony. Mr. Speaker, it is my submission that with the facts contested as they are, it is then difficult to use those facts to then make a determination on the preliminary issue. The next issue that I wish to submit on and emphasize is that the material that the governor wishes to rely on for his preliminary issue is the same material that the governor has brought forward or seeks to rely on as testimony in opposition to this motion. Mr. Speaker, members of the House, I wish to refer you now to Volume 2 of the governor's response to the motion that is before you. And in Volume 2, there is the statement at page 24, and this statement runs all the way to page 32 of one Salad Buro Guracha. Salad Buro Guracha is the clerk of the County Assembly of Isiolo. As I have said, in a most unusual way, he is a witness for the governor. He makes certain averments in that affidavit, which we need to test. Those averments have been repeated by other witnesses, and it is those averments that have been relied on by my learned colleagues on the other side in support of their assertion that there is indeed a preliminary issue that requires consideration and needs to be determined as a preliminary issue. Mr. Speaker, I wish to cede the remainder of our time to my colleague, Mr. Mawira. But as I take my seat, Mr. Speaker, I wish to make the following suggestion. Mr. Speaker, it is apparent in a rather blatant manner that the issues that have been brought as preliminary issues before you are not preliminary issues. Whereas they may be issues that are fit and proper for the determination of this House, but they are not fit and proper for determination as POs. My suggestion, Mr. Speaker, is that the PO be dismissed and that the governor has an opportunity then to ventilate those issues in his evidence in opposition to the motion, and that this House then makes a determination on those issues once it has had the benefit of hearing testimony from both sides, and both sides have had an opportunity to test that testimony. I'm much obliged.
Honorable Speaker, my name is Confis Mawira. I'll take the remaining time to buttress the submissions that have been made by my learned senior. Foremost, Honorable Speaker and members of this House, it is not contested that there is no order, there is no conservatory order stopping Senate from considering the impeachment motion that is before you. There is no order by court injuncting or enjoining this House not to proceed with the business of the day. What the governor challenges or impugns is the validity or otherwise of the impeachment motion that is before you. I submit, Honorable Speaker, that the question of validity of the impeachment motion is a question of interpretation and is reserved for the judicial arm or branch of government at the opportune time. As my learned senior, Nyamoji, has already submitted, we have authorities in the submission that we filed in response, and this Honorable House has given rulings in previous matters including the previous ruling in the matter of the impeachment of the governor of Kericho County, that legislative processes that are before Parliament, the moment this House or Parliament is seized with a resolution by a county assembly to remove office, this House becomes irreversibly seized of that impeachment motion, and no order of court can stop this Honorable House from conducting its business. More importantly, Honorable Speaker, that position has been adopted not only by this Senate or this Parliament, but by other parliaments world over. We have authority in the report of the Committee on the Proposed Removal from Office of the Governor of Embu County that the Senate becomes irreversibly seized of the matter the moment the Speaker of the Senate receives a letter from the Speaker of the County Assembly communicating the resolution of the Assembly to remove the Governor from office. The committee went ahead, Honorable Speaker, to quote similar positions adopted by parliaments in other jurisdictions, including Ghana, in the Supreme Court of the decision there, Honorable Speaker, Sri Lanka, and the United States. Honorable Speaker, the position that has been taken by this House in previous impeachment proceedings has been adopted by the highest court in the Republic. The Supreme Court, in the matter of the governor of the former governor of Embu County, Martin Wambora, and the Court of Appeal have agreed with this House, Honorable Speaker, that the judicial arm of the state cannot direct Parliament on what to do and not what to do. Therefore, it follows, Honorable Speaker, that at the opportune time when this Honorable House has conducted its proceedings, these proceedings will then fall before the judicial arm of the state. And at that time, the judicial arm of the state will have every opportunity to test the proceedings of this House for constitutional compliance. It is agreeable, it is common ground, Honorable Speaker, that the proper judge of compliance with the Constitution and the standing orders of this House and the statutes relating to the removal proceedings of a governor is the judiciary. The question or the point that is not agreeable by both sides is at what point can the courts stop an inchoate or an ongoing constitutional process that is before legislative assemblies. The Supreme Court, Honorable Speaker, in the matter of Martin Wambora, had occasion to deliberate on this issue. And at pages 6 of our submissions, page 6 and 7, Honorable Speaker, you will find an exposition of what the Supreme Court said. The Supreme Court explicitly forbade, Honorable Speaker, courts from granting orders that stop ongoing proceedings that are before legislative assemblies. And to quote what the court said at page 6, in fact, it is at page 7, Honorable Speaker, no governmental agency should encumber another to stall the constitutional motions of the other. The best practices from the comparative lesson signal that the judicial organ must practice the greatest care in determining the merits of each case. So, the question that arises, therefore, Honorable Speaker, is while the governor impugns or challenges the validity of the impeachment motion, the validity of the court order that was given, which court order is the basis of the challenge that the governor has put up to the propriety of these proceedings, is also in question. The validity of that court order is in question because, Your Lordship, because, Honorable Speaker, the highest court in the Republic have affirmed what this House has stated on numerous occasions, that the judicial arm of the state
though it can intervene to stop or to check for constitutional compliance, that process before the Legislative Assembly should be left to run its full course, and at the opportune time, the judicial arm of the state can intervene to check the propriety of those proceedings. Therefore, Honorable Speaker, can a court, the High Court, and Honorable Speaker, Section 5 of the Judicature Act provides for the hierarchy of laws in our republic. The Constitution is at the top. Honorable Speaker, the apex court in the republic, as per our Constitution, is the Supreme Court. The Court of Appeal is next. The decisions of the Supreme Court, as per Article 163(5) of the Constitution, Honorable Speaker, are binding on the High Court. The same goes for the decisions from the Court of Appeal. The question, therefore, is, can this Honorable House be stopped by a court that has disregarded binding precedent? Can this court be stopped by a court that itself is lacking in jurisdiction? Our response or our answer to that question, Honorable Speaker, is that you should proceed unhindered, undeterred, and render a decision or a determination on the impeachment motion on the merits upon hearing the witnesses that are to be called by the respective parties. The danger, Honorable Speaker, is if this Honorable House was to terminate the proceedings at this stage, then, Honorable Speaker, it would set a very dangerous precedent. And that dangerous precedent, Honorable Speaker, is that all that a governor would need to do is to move to court and obtain an order either quashing the impeachment proceedings before they even begin, or stopping this House from considering the impeachment motion before it is even seized with that impeachment motion. And therefore, Senate would have abdicated its role as a defender of devolution. Senate would have abdicated its oversight mechanism in the removal from office proceedings of county governors. And therefore, Honorable Speaker and the members, as you deliberate on that issue, we sound that caution that whatever is established today will have an implication on future impeachment processes that will be brought before this House. On the second ground of the PU, Honorable Speaker, counsel for the governor are referred to affidavits by the clerk of the Assembly and affidavits by the AP commander, Isiolo County. And all these affidavits, Honorable Speaker, have been referred to persuade you that there was no sitting by the Assembly on the 26th of June 2025 when the impeachment motion was approved by the County Assembly. The question that arises, Honorable Speaker, is whether the contents of those affidavits can established, whether the contents of those affidavits are to be believed without testing the evidence of those witnesses under oath. So the way I see it, Honorable Speaker, is that the governor is asking for a full trial. By making a reference to those affidavits, it must be taken that the governor concedes that that PO is not a pure point of law, is not based on a pure point of law, that can be canvassed by counsel without reference to affidavits by witnesses. The reason we file affidavits before you, Honorable Speaker, is to give advance notice to the other party, so that the other party can prepare on how to test the truthfulness, the credibility, and the veracity of those witnesses when they take the stand to give evidence before this House. So, Honorable Speaker, the contents of those affidavits, the depositions that are contained in those affidavits would have to be tested by way of cross-examination of the witnesses for this Honorable House to make a conclusion on that question as to whether there was a sitting. The same goes for the Hansard that is impugned by the clerk of the County Assembly on oath. With regard to the question of further on that question of the alleged forgery of the Hansard, all the counsel for the governor has done is to make reference to an affidavit by a witness. Counsel was submitting on what is supposed to be a preliminary point of law. It is no longer a preliminary point of law, Honorable Speaker, if counsel does not restrict himself and now, takes the posture of the witness and testifies on behalf of a witness on what they have deponed under oath in an affidavit. At the opportune time, Honorable Speaker, we'll be praying to cross-examine those witnesses in order to establish the truth. The further question that arises, Honorable Speaker, as I conclude, is the clerk of the Assembly under the County Assembly Services Act is required to render expert non-partisan advice to the Speaker and to the House on procedural matters and all other matters that are before the House. We will be craving for an opportunity to cross-examine the clerk on all the issues that Council has alluded to in trying to persuade you, Honorable Speaker, and the House that you dispose of the issue of whether there was a sitting and the issue whether there was forgery of the Hansard at this preliminary trial. A mini trial that the governor requests for, a trial within a trial, is not necessary, Honorable Speaker, if the issues that are to be canvassed during that mini trial can be established in the full trial. Or that the issues of the sitting of the Assembly, the issues of the alleged fraud, the alleged forgery, are matters that belong to the full trial. It is for the governor to prove that indeed there was forgery, because he's the one who alleges there was forgery of the Hansard report and that there was no sitting. It is for the governor to prove through evidence that is going to be tested by way of cross-examination at the trial. Therefore, Honorable Speaker, reducing that issue, and it's a very germane issue, the issue of the sitting and the alleged forgery, to a matter that can be handled at this stage without leading evidence, is not only inappropriate, but against the best interest of justice, because the County Assembly will not have the opportunity to cross-examine the witnesses that are being called, and whose affidavits have been referenced to by the Governor's Council in making that preliminary point. In conclusion, Honorable Speaker, it is only after a lengthy and a drawn-out hearing in the main trial that all these issues that are couched as preliminary objections can be sufficiently addressed. Honorable Speaker, I'll say one last thing on that issue of the court order before I cede a few minutes to my colleague, Mr. Muriuki. Honorable Speaker, the issue of the court order that is the governor has alluded to is not to be looked at just as a standalone issue or as it is essentially, Honorable Speaker, an attack on the jurisdiction of this Honorable House to hear the impeachment motion that this House is seized of. The question, as I said before, is if a court whose jurisdiction is challenged, because in fact, Honorable Speaker, I was in those proceedings and the jurisdiction of the court was challenged, the court has not rendered a decision on a preliminary objection that was filed, but the court proceeded to grant the orders that were granted? Can a court whose jurisdiction is challenged and which court, the apex court in the Republic, together with the Court of Appeal, have held that our court is bereft of jurisdiction, take away the jurisdiction of this House, which is constitutional in nature, the jurisdiction of this House to oversight county assemblies is constitutional in nature. Can a court acting in excess of jurisdiction take away the constitutional mandate of this House? As Mr. Nyamodi quoted just before he took the stand, Honorable Speaker, the decision in Mark 4 on the validity of that court order comes into play. Because, Honorable Speaker, there is no need for that court order to be set aside. The moment that court order was given by a court that has disregarded binding precedents from the Supreme Court, from the Court of Appeal, and acted in excess of jurisdiction, that order is a nullity in law. So much as the court order says that the proceedings before the Assembly were a nullity in law, the court order itself is a nullity in law. There is no further order of court that is required to set aside that order, because that order itself is a nullity in law. It cannot stand. Therefore, Honorable Speaker and the Senators, I urge you, as I conclude, not to cede to the request, not to accede to the request by the governor's lawyers to take away the jurisdiction of this Honorable House on this important question that is before you for determination. I will cede the remaining minutes to my colleague, Mr. Murray.
Honorable Speaker, esteemed members of this House, my name is Eric Murioki. I am privileged to appear before you once again. I represent the County Assembly of Isiolo. Honorable Speaker, esteemed members, to continue with our submissions where my colleague has left off, the question that should seize this House, and Honorable Speaker, when you go to make your determination, is this: on a balance of conveniences, what ought to happen? We submit that this House ought to proceed with these proceedings because, as has been held in numerous court decisions, the governor will have the opportunity to challenge these proceedings in court. However, neither the court nor this House can freeze the statutory and constitutional timelines that are set for impeachment proceedings. So, Honorable Speaker, allowing the PO in the way that the governor's team asks this House to do would irreparably prejudice the Assembly, because there is a chance for the governor to challenge these proceedings, but there is no chance for the Assembly to reinstate or to pause this process and then come back. The proper time to question the validity of impeachment proceedings, as has been ably submitted by my senior Nyamodi, is after the process is complete. And Honorable Speaker and members, this is what the court held in the case of Kawira Mwangaza versus the County Assembly of Meru. Honorable Speaker, this position was also buttressed or had earlier been held in the Justice Kariuki matter. Honorable Speaker, allow me to read an excerpt from the decision of the Court of Appeal, that is Mwangaza versus County Assembly of Meru and another, 2023 KECA. We observe that the applicant's right to be heard and to defend herself from the allegations made against her in the impeachment debate at the County Assembly of Meru provided under the standing orders of the County Assembly. If she is impeached, and emphasis on this part, Honorable Speaker, she will have another opportunity to present her case before the Senate during the hearing of the impeachment motion. Further emphasis here, Honorable Speaker, even after the Senate makes its decision, the applicant still has the avenue of petitioning the court for an appropriate relief if the decisions were to go against her. We are therefore of the considered view that the applicant's right to be heard will not be circumscribed. Enough said, this court lacks jurisdiction to consider the application before it for the reasons stated in the ruling. That is the Court of Appeal, Honorable Senators speaking. The second question that this House and Mr. Speaker should ponder is, where is the public interest in this matter? In this matter of the PO. This is an important question. The impeachment process has commenced. The Supreme Court and the Court of Appeal have in very clear said on that issue.
Counsel for the County Assembly.
Yes.
Just take your seat. I've got a communication to make. Now, honorable senators, ladies and gentlemen, the time now is 1 p.m. And in terms of our program, we are set out in the order paper. We are set to adjourn at this time. I note, however, that the County Assembly still has 10 minutes of their time. I therefore wish to invoke Standing Order 34.2 and 2A of the Standing Orders, which permit the Speaker, for the convenience of the Senate, to direct later interruption of the business for a period of not more than 15 minutes. I therefore direct that the County Assembly may utilize its remaining 10 minutes so that the Senate shall adjourn at 1:10 p.m. or such earlier time as the County Assembly concludes its submissions. The Senate then will resume sitting at 2:30 p.m. when the Governor's Council will have its 10 minutes to respond before the Senate proceeds to make a determination on the preliminary objection. It is so directed. Council, you may proceed to utilize your 10 minutes.
Thank you, Mr. Speaker, sir. As I was submitting, honorable senators, is that my colleagues have indeed said, and I agree completely, that forgery must be specifically pleaded and proven. The mere word of the Governor's Council on this pulpit cannot be taken as evidence of forgery. Indeed, in a decision of the Court of Appeal, Jennifer Nyambura Kamau versus Humphrey Bakanandi, the court held that it is also a settled law that fraudulent conduct must be distinctly alleged and distinctly proved. It is not allowable to leave fraud to be inferred from the facts. An allegation of forgery is an issue of fraudulent conduct. Honorable senators, you have been told that it is a preliminary issue whether there was a sitting and whether from that sitting threshold for impeachment was reached. Honorable senators, this issue can only be determined after a conclusive hearing of these proceedings. The Governor's Council has stated that they will rely on the affidavit of the clerk, who is an employee of the county assembly, to tell you that there was no sitting. Honorable Senators, as a matter of fair hearing, we must then be allowed to test the veracity of those averments by the clerk under oath through cross-examination. And for that reason, Honorable Senators, this issue cannot form the basis of a PO. Honorable Senators, from the locus classicus on POs of Mukisa Biscuits, as was again affirmed in the decision that we have quoted in our submissions of Ali Hassan Joe and another versus Suleiman Said Shaban, for a PO to succeed, it must be a pure point of law which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. And I would perhaps just amend that to also include quasi-judicial discretion, because this House now sits as a quasi-judicial body. So, Honorable Senators, that issue of whether there was a sitting is at length canvassed in both the County Assembly's documents and the Governor's responses. And for that reason, it therefore cannot form part of a preliminary objection. We shall be, of course, adducing evidence to show that there were sittings of the Assembly on those 2 dates, even though there were attempts to scuttle those sittings. Honorable Senators, as I conclude my submissions, we shall lead evidence at the opportune time to show that there was vandalism at the offices of the County Assembly and that the said vandalism was orchestrated by the Governor or at his direction. That is the evidence that we shall bring here. We shall also lead evidence, Honorable Senators, to show that there has been a pattern of attempts to scuttle these impeachment proceedings right from the start, and these attempts were made by the Governor. We shall adduce evidence to show that the Governor took every possible step, whether legal or otherwise, to try and stop and scuttle these impeachment proceedings. For these reasons, Honorable Speaker and Honorable Members, we submit that it is necessary and this House ought to rule that that PO is untenable and that we proceed with hearing of the full case. My colleague will finalize our submissions. Thank you.
Honorable Speaker and members of the Senate, I'll just take a few minutes just to conclude our remarks on behalf of the County Assembly. Honorable Speaker, I would just like to highlight the two-faced approach to the contest raised by the Governor. On the one hand, the Governor is saying that there was no motion, no resolution passed that is capable of coming before the Senate.
Counsel, for the sake of the Hansard, kindly state your name.
Honorable Speaker, my name is Paulo. Honorable Speaker, before I proceed, my name is Paul Wafula. I'm an advocate. I'm part of the team representing the County Assembly. Honorable Speaker, given the disruption, may I kindly request that I be added some time since I have not utilized my time.
4 minutes.
Most obliged. Honorable Speaker and members of the Senate, I would kindly request to conclude the remarks of the County Assembly by demonstrating the two-faced nature of the contest that the governor has raised. On the one hand, Honorable Speaker and members of the Senate, you are being told that there was no resolution passed by the County Assembly to impeach the governor. And it is for that reason that my learned friends took detailed time to take you through the Hansard, through their evidence, just to show that actually there was no motion or no resolution passed. On the other hand, they have made it a point to say that there is a resolution. However, that resolution has been declared null and void by a High Court order. Ipso facto, what the governor is saying, on the other hand, is that actually the County Assembly sat and passed a resolution. And on the second hand, they took that resolution and went to the court, where the court adjudicated on that resolution and found it to be null and void. Honorable Senators and the Speaker, the governor needs to take a position. Is it that there was no resolution or there was a resolution? Honorable Speaker and members of the Senate, you have not been told in any uncertain terms there is any constitutional or statutory provision barring this House from conducting its business today. You have not been told that there is any court order barring these proceedings. Absent those two parameters, it is our submission that there is no preliminary objection capable of being sustained in these proceedings. Honorable Speaker, as I conclude, you will note from the various remarks made by my learned friends for the governor and ourselves that the record of whether or not the County Assembly of Isiolo sat is contested. There is a rebuttable explanation for that, and that can only be made when the County Assembly is given an opportunity to present its case. On that basis alone, Honorable Senators and Speaker, we kindly ask this House to disregard the PO raised in the manner it deserves and proceed to hearing. Most obliged.
Thank you. Be rise. Honorable Senators, it is now 1:14 p.m., time to adjourn the Senate. The Senate therefore stands adjourned until later today, Tuesday, the 8th of July, 2025, at 2:30 p.m.